Hello, once again, this is Antonio, and I'm coming at you with another exciting video. Now, Dad was told if he don't do some upfront payments, then he will be denied access to his child. So, the word in the terminology that was used was deviations. If he didn't do any deviations, then he would be denied access to the child. Well, in the court of law, money doesn't equal access to a child, right? There are tons of people that do not have a job, and the court system still would like for them to participate in some kind of um, parental bonding with their child. So let's go ahead and dive into this video. This is for fair use. You definitely put it on in the comments and tell me, how do you feel? Is mom in the right or is dad in the right? Let's go ahead and rock and roll.
Was before I was involved in the case and is pure fantasy.
I don't know his monthly income, Your Honor, but I see Miss Haskell shaking her head no.
I'm not sure how she would know that, but
The last time he filed income taxes, his net, or well, prepared income taxes, he didn't actually file them. His net was $175,000. That was net.
he doesn't make anything close to that.
Dad was told he wouldn't see his son if he didn't agree to an upward deviation of child support.
The parties were in the front of the court back in September 21st of 2022, during which time they discussed custody, parenting time, and child support, putting an agreement on the record for all of those issues. And during that time, there was a recommendation of $312 per month in child support. And during that hearing, the parties both agreed to a $1,200 per month rather than the $312 per month. An order was never entered to reflect that $1,200 per month. Mr. Haskell did pay $1,200 per month to Miss Haskell until February 10th of 2023, at which time that full amount of the $1,200 ceased, and I believe Mr. Haskell then began paying the old amount that was in the recommendation of $312 per month. And as I mentioned in the motion, the order or in order was not entered to reflect the agreement of $1,200 per month. Rather, it stayed at the $312 per month, despite the parties' agreement, and stated that it was in the best interest of the minor child to adopt the $1,200 per month in child support. So what we're essentially asking for today is, in order reflecting that amount, an acknowledgement that the amount was paid through February 10th of 2023.
And then since February 10th, are you indicating the payment has been the $312 a month?
Yes, and Ms. Haskell can correct me if that's wrong, but my understanding is yes, it's been $312 per month since that time.
Is he paying that directly to her or through the state?
Aubrey, are you able to answer that question as whether it's going directly to you or through the state?
He's paying it directly to her.
Yeah, and also he's paying basically 300, and sometimes he pays a 312, sometimes he pays 300, sometimes he's paid like 307. Yeah, it's not very consistent.
Thank you. Mr. Blumber, what is your position regarding the motion?
I'm shocked and astounded that counsel would come before the court and not tell the court that the parties went to mediation in April, came up with an agreement that provided for joint legal and joint physical custody with equal parenting time. The child support recommendation should be based on the existing parenting time per the agreements of the parties. Moreover, I received a proposed judgment from counsel that specifically adopts that joint legal, joint physical custody with parenting time a week on, week off throughout the year. The fact of the matter is that the plaintiff is denying my client the parenting time that she agreed to, and that is reflected in not only the mediation agreement, but the judgment of divorce. So our position is the recommendation of $312 should be the order of the court based on the agreed upon parenting time schedule. This $1,200 was before I was involved in the case and is pure fantasy.
Well, and I would strongly object to the statements made by Mr. Blumberg. The parties did mediate, but there was no mediation agreement. And so any proposals back and forth, I believe, would violate Michigan Rule of Evidence 408. There are proposals that have gone back and forth, but there is no agreement on the record, or there is no mediation agreement regarding an adjusted custody or parenting time schedule.
With all due respect, is counsel taking the position that you haven't provided me with a proposed judgment that reflects the agreement of the parties of a week on, week off, or am I making this up?
We've provided a proposed agreement to counsel, but the parties do not have an agreement yet at this time. And in speaking with Ms. Haskell, the parties are not currently exercising equal parenting time.
Because your client will not live up to the agreement of the mediation or the proposed judgment.
And again, Your Honor, there is no mediation agreement. There were proposals back and forth, but the parties didn't reach a final agreement on anything in mediation.
Okay, well, order-wise, I know back in September, there was the order based on that prior hearing, and I know at that hearing, there was an agreement to deviate to the 1,200. It does not look like that was then memorialized into a support order. It just indicated that they were going to deviate to that amount when they entered their judgment of divorce. I think the thought at that time was they were going to then quickly proceed and get the matter finalized. So front of the court did not prepare at that point a support order, because the thought was that the parties were then going to get their paperwork together and get it finalized, and then would deviate to that 1,200. However, that didn't happen. Obviously, now we are almost a year away from when that happened. Mr. Blumberg, do you agree that your client was paying the 1,200 up until February?
Again, that was prior to my involvement. I don't know what he paid, or even, I think both parties were unrepresented at that point.
They were, yes.
And he clearly didn't know what the child support recommendation would be. He was, from my understanding and recollection, property issues were being held over his head. He was even told by the plaintiff he wouldn't see his son if he didn't agree to this. That's my recollection. And again, if I misstated it, I apologize, but that is what I was told. I mean, it's just incredible to me that the plaintiff is now taking the position that there was no agreement, yet he prepares a proposed judgment which absolutely incorporates what was the agreement of the parties.
Again, it captures what a proposal was, but there was no agreement. The mediation ended when, I'm not going to get into that. I don't want to violate any of the rules of evidence, but again, there was not a finalized agreement between the parties.
Certainly as to property, he's correct. As to custody, parenting time, that was resolved at mediation.
And then Mr. Blumberg, so your client's position is he's not at this time agreeing to deviate to the 1,200?
No, he has been paying this $312 consistently since February.
And I know, Mr. Backlund, in your motion, there was a comment that perhaps there wasn't appropriate financial information in that first calculation. Do you believe that is true?
I believe it was, and I think in reviewing the record, there was a comment somebody made off camera that suggested the same, that all the information wasn't provided or captured by the friend of the court at that time in the recommendation.
That had Mr. Haskell at a gross income of about $6,750 a month. Do you feel that that is not accurate?
I don't know his monthly income, Your Honor, but I see Ms. Haskell shaking her head no.
I'm not sure how she would know that, but certainly the timber.
The last time he filed income taxes, his net, or well, prepared income taxes, he didn't actually file them. His net was $175,000. That was net.
He doesn't make anything close to that.
He stopped working consistently. That's
All right, hold on. So are the parties at a point where they think they're going to reach an agreement and submit a consent judgment, or do you think that's not happening at this point?
That's a good question, Your Honor. As mentioned, I sent a proposal to Mr. Blumberg, but again, I'm sure there needs to be further discussion as to whether or not that will be adopted by the parties.
And I would agree with that as it relates to the property issues. The issues of custody and parenting time, genuinely believe it was resolved both through mediation and is reflected in the proposed judgment. I mean, there's
we have a parenting time order in place.
Hold on, ma'am. You gotta let your attorney speak for you unless we ask you to, okay? I do remember that there was, at that first hearing in September, or August when that was, there was a discussion of deviating to the 1,200. I don't see that there was ever anything filed to stop that, but that also was never memorialized into an order. So I think what is appropriate is for the front of the court to submit a new support recommendation, and for the parties to submit, since it was done a while ago, new financial information also.
And Judge, the only thing that I would ask is that if the plaintiff's position now is we don't have an agreement on custody and parenting time, then we'd ask the friend of the court to do two recommendations. One based on an 182.5 overnights, as is reflected by the proposal prepared by Mr. Backlund, and then alternatively, the 101 overnights.
All right, so I think the current order gives him 101 overnights. Is that correct? Every other weekend, 2 weeks in the summer. So that's the actual order that's in place. Is that correct? But Mr. Blumberg, you're indicating that it might change, that there's been a proposal to change it, but that the actual current order is the every other weekend and then the time in the summer. Is that correct?
Yeah, that's correct. But we're also asking the friend of the court, if it isn't a huge imposition, to prepare one based on what I believe is the agreement of the parties.
Yeah, that's certainly not a problem, since they'll have all the figures. So they can do one on the 101 and then one as to equal. And then, the more difficult is the effective date, I think, at this point.
I guess we can argue that once the recommendation comes back. I mean, our position would be at the date of the mediation in April.
Right, because I'm not going to go back in time. Obviously, he was paying the $1,200 for a while voluntarily, so I'm not going to give him extra credit if that's what the parties had agreed to and he was paying. So I think we would go back to the time when that stopped happening.
I think that was February of 2023.
So like February 10th, I think is what it was.
Yeah.
Okay. All right. So we'll draft the new recommendation. So the 101 overnights will be the recommendation, and then we'll do an informational recommendation for the 182 in case that's where the parties fall when they resolve this matter. You'll have that already prepared.
Sounds good. Thank you.
Mr. Backlund, anything additional?
Nothing further, Your Honor. Thank you.
All right. Thank you both for appearing. That does conclude the matter. You may sign off.
Okay, so you clearly see that mom at one point was paid greatly over what they agreed upon. Then she tried to say that his income, his net, was $175,000. She tried to butt in and say, well, I saw him, he didn't file his taxes, but he prepared it, and this is what it says. All right, so what it says, why would he just probably pay to have his taxes done and then not file them? I'm not sure. That doesn't even make sense. That's a good question, Miss Jessica. I'm not sure. Some of this stuff just doesn't make sense in itself. The lawyer, I like the dad's lawyer. The dad's lawyer wouldn't back it down, and he definitely spoke up for the dad. Mom lawyer, he did his own thing as well. He did his thing as well, but I like the dad's lawyer. He was very assertive, and he was basically speaking on behalf of the client. But it doesn't make sense, like you said, Jessica. Why would he properly pay to have his taxes done and not file them? It doesn't make any sense, and mom don't have any proof that he made $175,000 unless he was doing this due diligence to try to hide money from the mom. You just never know. But I'm only here to report on these cases and do follow up on these cases. But nevertheless, this is Antonio with Team Tiggio. Please like, comment, subscribe, hit the notification bell as we're on the road to 6,000 subscribers. And once again, we will see you in the next video.